What does it mean to be denied equal protection of the laws? Is it enough to show that a law disproportionately harms one group over another? Or must we also prove that lawmakers intended that harm? When courts look at inequality, are they judging outcomes or trying to read minds? These questions go to the heart of how the Constitution understands equality, and the answers today owe more to Plessy versus Ferguson than most would like to admit. While the infamous 1896 case is widely condemned for upholding segregation, its deeper legacy lies in something more subtle and more enduring, a method of judicial reasoning that treats inequality as a matter of perception and harm as something that must be proven through motive. While most Americans think Plessy versus Ferguson was killed by Brown versus Board of Education in 1954, that decision was far less sweeping than the legend would tell. The doctrine of separate but equal, we are told, was exposed as a lie, repudiated by science, morality, and Brown's declaration that state-imposed segregation is inherently unequal. According to this familiar story, Plessy was banished from constitutional law forever. But what few people realize is that Plessy never truly disappeared. While Brown overruled Plessy's result, Plessy's method of analyzing the Equal Protection Clause survived. And today it quietly governs how courts interpret the 14th Amendment's guarantee of the equal protection of the laws. In a very real sense, the Supreme Court partially overturned Plessy, but left its core approach intact. The result is a distorted, piecemeal, equal protection jurisprudence that strays far from the amendment's text and history. Today, we directly attack Plessy's lingering legacy. We argue that Plessy needs to be fully overturned, not just in outcome, but in the interpretive method it introduced. Only by exorcising Plessy's ghost can the Equal Protection Clause return to its original meaning. A meaning focused on denying actual inequality rather than scrutinizing governmental motives. This approach, far from radical, hews more closely to the 14th Amendment's text, the intent of its framers, and the Supreme Court's early precedents than the prevailing doctrine does. It's also an argument likely to garner broad public support. Americans would be shocked to learn that a pillar of Jim Crow still casts a shadow over our equality jurisprudence. When the 14th Amendment was ratified in 1868, its language was spare and blunt. No state shall deny to any person within its jurisdiction the equal protection of the laws. Notably, the text makes no mention of intent, purpose, or motive. The constitutional violation it identifies is a denial of equal protection, something that is done to persons, not something that exists in a lawmaker's heart or mind. In plain terms, the clause is outcome-focused. It prohibits states from depriving any person or class of the equal operation of law. This textual emphasis reflected the realities of the Reconstruction era. The drafters of the 14th Amendment were not primarily concerned with ferreting out secret malicious intent. They were battling the black codes, laws that were often race-neutral on their face, but oppressive in practice. In the wake of emancipation, Southern states enacted ostensibly neutral laws like vagrancy statutes, labor contract requirements, and restrictive licensing rules that in practice systematically deprived Black Americans of basic rights. Congress responded with the Civil Rights Act of 1866, designed to secure equal practical rights for the freedmen. Tellingly, that act forbade state officials from subjecting persons to different punishments, pains, or penalties based on race. The emphasis was on what was done to people, the unequal burdens imposed, rather than the invisible intent behind the law. Equality meant equal legal consequences, not merely good intentions. Early interpretations of the 14th Amendment reflected this understanding. The framers' original intent, and the amendment's public meaning, treated the Equal Protection Clause as a broad ban on laws or actions that created caste-like inequalities, irrespective of whether those inequalities could be tied to an official's bad motive. In short, the Equal Protection Clause was understood as a shield against systems of caste and class legislation, not merely a rule against overt bigotry. For roughly the first 30 years after ratification, the Supreme Court's equal protection decisions were straightforward, textual, and focused on effects. The Court treated the clause primarily as a prohibition on class legislation, laws that systematically burdened one class of persons while exempting others. If state action in fact deprived a group of equal rights or protection, it was unconstitutional, motive aside. This approach is evident in a series of now largely forgotten cases in the late 19th century, which we might call the lost generation of equal protection. Strouder versus West Virginia in 1880. West Virginia had a law excluding black citizens from jury service. The Supreme Court struck it down as a violation of equal protection, reasoning that the law singles out black people and brands them with legal inferiority, denying them an essential aspect of legal protection. Crucially, the Strouder Court did not inquire whether the legislature hated black people or intended to stigmatize them. It was enough that the law expressly discriminated and thereby denied a class of citizens equal rights. As the court put it, the 14th Amendment guarantees exemption from discriminations imposed by public authority, which imply legal inferiority in civil society. The harm was in the classification itself and its effect, not the lawmaker's state of mind. Ex parte Virginia, also in 1880. On the same day as Strouder, the court decided ex parte Virginia, upholding the federal prosecution of a county judge who had excluded black citizens from juries. The judge argued that only legislative acts, not individual officials' conduct, could violate the 14th Amendment. The court emphatically rejected that notion. It confirmed that any state action, including a judge's action, that in fact produces racial exclusion, violates equal protection. Again, the focus was on outcome. The denial of jury service to a class of people was the constitutional injury, regardless of whether a specific intent could be proven. Yick Wo v. Hopkins in 1886. This is the era's most famous illustration of effect-based equality. San Francisco had a facially neutral laundry ordinance requiring permits to operate in wooden buildings. In practice, nearly all Chinese applicants were denied permits, while virtually all white applicants were approved. The Supreme Court unanimously ruled that the unequal administration of the law violated equal protection, even though the ordinance on its face did not mention race. The court famously declared that even if a law appears fair in form, it violates the Constitution if it is enforced with an evil eye and an unequal hand. In other words, a pattern of discriminatory effects, so stark that it could only be explained by bias, was sufficient to prove a constitutional violation. Notably, the Yick Wo court did not demand direct evidence of the official's subjective intentions. The outcome, all Chinese laundry owners were shut down while non-Chinese were allowed to operate, was itself conclusive of a denial of equal protection. Through these and other decisions, the early court read the Equal Protection Clause as it was written, as a broad command that no state shall deny equal protection. If a law or action created an unequal condition, a denial of a right or immunity to a disfavored group, the clause was violated. The logic was structural and substantive. The state may not systematically favor one class over another in the provision of laws and protections. This approach hewed closely to the Reconstruction Congress's aim of eliminating caste legislation. It did not require plaintiffs to psychoanalyze legislators or produce smoking gun evidence of racial animus. Outcome was paramount. In sum, the Reconstruction-era understanding of equal protection was practical and non-metaphysical. The clause guaranteed equal laws and equal justice, and it condemned any legal scheme that denies to some citizens the equal protection of the laws. This understanding, however, was about to be upended by a case that is remembered for something else entirely. When the Supreme Court decided Plessy versus Ferguson in 1896, its immediate holding was the now infamous separate but equal rule. The court upheld a Louisiana law requiring racially segregated railroad cars, pronouncing that segregated facilities did not violate the Constitution so long as they were purportedly equal. This outcome, blessing state-imposed racial segregation, was morally and legally disastrous. But Plessy's deeper and more insidious legacy lies in how the court reached that result. In Plessy, the court subtly but profoundly redefined what counts as a constitutional harm under the Equal Protection Clause. Justice Henry Brown's majority opinion in Plessy reasoned that if a law treats the two races formally the same, meaning it requires separate accommodations for both black and white passengers, then there is no legal inequality. The court dismissed the plaintiff's argument that segregation stigmatizes black people. Any such feeling of inferiority, the court declared, was not by reason of anything found in the law, but solely because the colored race chooses to put that construction upon it. According to Plessy, so long as the black and white railway cars were equal in amenities, any sense of unequal treatment was merely subjective, a matter of black people's perceptions, not a denial by the state. With that move, Plessy performed a doctrinal sleight of hand. It displaced the earlier focus on social reality and practical inequality and replaced it with a formalistic focus on the superficial symmetry of the law. Under Plessy's approach, context and outcome no longer mattered so long as the law was equal in the abstract. The court could thus ignore the actual social meaning and impact of segregation, the creation of a racial caste system, by defining the harm away. If facilities were labeled equal, then by legal fiat, no one was denied equal protection, regardless of the obvious real-world inequalities and stigmas involved. Importantly, Plessy did not explicitly hold that discriminatory intent was required for an equal protection violation. Intent wasn't the focus because the law openly classified by race. Instead, Plessy's innovation was more subtle but enduring. It taught courts to look away from consequences. It encouraged judges to confine their analysis to the four corners of the law. Is it facially symmetric? And to treat social context and effects as legally irrelevant. By reducing equality to a narrow question of form, Plessy shrank the Equal Protection Clause's scope dramatically. Under this view, so long as a law did not explicitly put one race below another in the text, the actual inferior status imposed on one group could be ignored as a choice of the oppressed to feel injured. This formalism was a drastic departure from the Reconstruction Court's approach. The Plessy majority, in effect, resurrected the very theory of caste that the 14th Amendment was meant to reject, while pretending to abide by the amendment. As Justice Harlan's famous dissent in Plessy pointed out, the Constitution is colorblind and neither knows nor tolerates classes among citizens. Harlan warned that the court's decision was creating a second-class status, a badge of servitude, inconsistent with the amendment's purpose of eliminating caste. But the majority's methodology ensured that so long as the law was formally equal, with two races separated in parallel, no badge would be legally recognized. In sum, Plessy's true jurisprudential crime was not just its explicit approval of segregation, but its redefinition of constitutional equality in formalistic terms. It changed the question that courts ask from, what is the actual effect of this state action? Does it deny a group equal protection? To, is there a formal disparity on the face of the law? If not, any inequality of outcome is outside our concern. That methodological shift would cast a long shadow, one that even Brown did not entirely escape. In Brown v. Board of Education, back in 1954, the Supreme Court famously struck down racial segregation in public schools, finally overruling Plessy's separate but equal doctrine, at least in the realm of education. Brown recognized that segregated schools are, quote, inherently unequal, acknowledging that the separation itself stigmatized black children and deprived them of equal educational opportunities. By focusing on the real-world effects of segregation, the harm to black children's hearts and minds, their educational outcomes and their place in society, Brown repudiated Plessy's core premise that legal segregation could ever be truly equal. The decision was a monumental course correction for constitutional law and American history. However, a close look at Brown shows that the court was careful, too careful, in its reasoning. Chief Justice Warren's opinion for a unanimous court did not announce a broad return to the Reconstruction-era understanding of equal protection. It pointedly confined its rationale to public education, emphasizing the unique importance of schools in democratic society and children's development. The court did not reject Plessy's formalistic framework. It avoided any sweeping statement that all laws with racially disparate impacts are unconstitutional. In fact, the court did not articulate a comprehensive theory of the Equal Protection Clause at all. It simply held that in the context of public education, enforced segregation is unacceptable because separate facilities are inherently unequal in that context. Why does this matter? Because by not overruling the method of Plessy head-on, Brown left the door open for Plessy's approach to survive in a subtler form. Brown broke Plessy's explicit rule that separation is allowed if equal, but it did not completely break free of Plessy's frame of analysis. Outside of the specific realm of school segregation, the court still needed a way to handle the multitude of other government actions that produce racial inequalities. And, absent a clear directive to return to an effects-focused interpretation of equal protection, the path of least resistance was to continue something like Plessy's formalism in other contexts. In short, Brown overruled Plessy's conclusion, but arguably preserved the Plessy worldview that unequal social outcomes are not the Constitution's concern unless intentional. The years after Brown would make this clear. After Brown, the Supreme Court faced an immense challenge. If the reality of inequality mattered, as Brown implicitly acknowledged it did, at least for schools, then what about the vast array of laws and practices beyond education that produced racially disparate outcomes? By the mid-20th century, de jure segregation in schooling was just the tip of the iceberg. Housing policies, voting rules, criminal justice practices, employment criteria, municipal service allocations, many of these were race-neutral in text, but contributed to profound racial disparities, in fact. If the Equal Protection Clause was truly about equal outcomes before the law, courts would potentially have to scrutinize any government policy that disproportionately burdened a racial group, even absent overt discrimination. This raised practical and political concerns. Would courts become roving social problem solvers overseeing every law's impact? Where do you draw the line between a mere disproportionate effect and a constitutional violation? The judiciary, wary of overextending its role, looked for a limiting principle, a way to cabin Brown's application and avoid a flood of claims based on disparate impact. The solution the court arrived at was, in effect, to resurrect Plessy's formalism under a new guise. Instead of openly denying the relevance of unequal outcomes, as Plessy had done, the court adopted intent doctrine, a rule that a facially neutral law with a disparate racial impact violates the Equal Protection Clause only if plaintiffs can prove the disparity was caused by intentional discrimination by the government. In other words, disparate impact alone would no longer suffice. It had to be linked to purposeful bias. This approach first crystallized in Washington v. Davis in 1976, where black plaintiffs challenged the D.C. Police Department's written entrance exam that black applicants failed at a much higher rate than white applicants. The Supreme Court, while acknowledging the stark racial gap in pass rates, held that the Constitution is not violated by a law or policy that disproportionately affects one race unless plaintiffs can show it was adopted because of, not merely in spite of, its adverse effects on an identifiable group. The Davis Court declared that, quote, disproportionate impact is not irrelevant, but it is not the sole touchstone of an invidious racial discrimination forbidden by the Constitution. In other words, a neutral law with unequal effects standing alone does not trigger any heightened scrutiny. There must be proof of a racially invidious purpose, a showing that officials intended to discriminate. On the surface, this intent requirement was framed as a reasonable check on judicial intervention. The court expressed concern that ruling purely on disparate impact could make almost every law susceptible to attack, since few laws are impact neutral across all groups. It cast the intent test as a way to ensure courts only strike down laws for truly invidious discrimination, rather than second-guessing all policy choices with unequal statistics. This sounded like judicial restraint. In reality, however, Washington v. Davis reimposed Plessy's logic in a modern form, requiring proof of subjective intent before a racial disparity can count as unequal effectively insulates most structural inequalities from constitutional remedy, just as Plessy's focus on formal equality insulated segregation from scrutiny. Under the intent doctrine, laws that produce or perpetuate racial inequality, employment tests, zoning decisions, school districting, policing tactics, and so on, are beyond the reach of equal protection so long as they are facially race-neutral and cannot be traced to a smoking gun racist purpose. The focus is once again on form rather than function. Structural injustice, systems where the law in operation denies equal protection, became exceedingly hard to attack unless one could find proof akin to an admission of bigotry. Subsequent cases only tightened this doctrine. In Personnel Administrator v. Feeney, decided in 1979, the court applied the intent test to a law that gave hiring preference to veterans, over 98% of whom were male, thus severely disadvantaging women in civil service. The court acknowledged the law's drastic, disparate impact on women, and even that this impact was foreseeable, but it held that wasn't enough. It ruled that, quote, discriminatory purpose implies that the decision-maker selected or reaffirmed a particular course of action, at least in part, because of, not merely in spite of, its adverse effects upon an identifiable group. In plainer terms, even if lawmakers knew a neutral law would disproportionately harm a group, as long as harming that group wasn't their conscious objective, the law would not violate equal protection. Mere awareness of disparate impact does not equal intent to discriminate under this standard. In McCleskey v. Kemp, in 1987, the court confronted a rigorously documented study showing extraordinary racial disparities in Georgia's application of the death penalty. Defendants accused of killing white victims were far more likely to be sentenced to death than those who killed black victims, and so on. The evidence showed a systemic bias affecting hundreds of cases. Yet the court, in a contentious 5-4 decision, refused to infer unconstitutional discrimination from the statistics. It held that to succeed, a defendant must prove that his own death sentence was the product of intentional discrimination. The majority infamously wrote that accepting McCleskey's claim would open the door to widespread challenges in other areas of law, implying that the justice system itself would be called into question. In essence, even overwhelming statistical evidence of systemic racism was not enough. Absent a smoking gun showing the decision-makers in that very case acted with racial bias, the equal protection claim failed. The message was clear, broad patterns of racially skewed outcomes, no matter how egregious, are constitutionally invisible unless tethered to proven intent. The upshot of these decisions is that the Equal Protection Clause, which was written to prevent states from systemically denying equal rights, has been construed in modern law as a much narrower safeguard. It largely polices deliberate bigotry or bad thoughts by government actors, rather than outcomes. This dramatically narrows the clause's power to address racial inequality. As one scholar put it, the 14th Amendment has been transformed from a shield against caste into a rule against racists, effective only against the most blatant discriminatory purpose, and largely impotent against the more pervasive structural forms of inequality that characterize our society. It is deeply ironic that the prevailing intent-focused interpretation of equal protection is often defended as a neutral or conservative approach, when in fact it is fundamentally at odds with the original meaning of the 14th Amendment. Self-described originalists on the modern court have embraced the intent doctrine as if it were gospel, but the historical record contradicts it at every turn. The text. The amendment's words forbid states to deny to any person the equal protection of the laws. That language specifies an act, deny, an object, equal protection, and a result to any person. It says nothing about the thoughts or motivations behind the act. If the drafters meant to require a showing of malicious intent, they could have written the clause differently. For example, no state shall intentionally deny or with a discriminatory purpose deny, but they did not. The choice of wording, deny equal protection, naturally focuses on the effects of state action, denials of protection, rather than the psychological state of government officials. Historical context. As discussed, the Reconstruction Congress was combating laws like black codes, where the harm was in the impact on freedmen's rights, regardless of polite pretexts. The Civil Rights Act of 1866 aimed to eliminate outcome inequalities, like harsher punishments for black people, whether or not those laws explicitly said black or were passed out of hatred. Lawmakers in 1866 to 1868 spoke in terms of substantive rights and preventing oppression, not in terms of smoking out hidden racist motives. The concern was unequal laws and practices, period. Early precedent. The first generation of Supreme Court cases under the 14th Amendment, Strouder, Yickwo, and so on, confirmed that understanding. They struck down laws that in effect discriminated or applied in a discriminatory way without any inquiry into subjective legislative intent. This wasn't because the 19th century court was more liberal or activist. It was because the notion that equal protection required proof of malice was foreign to the amendment's basic guarantees. The Reconstruction Court took it as self-evident that a law segregating by race brands a class and is forbidden by the amendment, motive aside. Given this history, the discriminatory purpose rule established in the 1970s is profoundly unfaithful to the 14th Amendment's original public meaning. It is a modern judicial invention, one that arrived precisely when the court felt pressure to limit Brown's egalitarian promise. In a twist of fate, the conservative intent doctrine rests on Plessy's anti-textual foundation. It carries forward Plessy's deviation from the original understanding, albeit cloaked in the language of neutrality. Stated plainly, those who champion the intent test in the name of judicial restraint or fidelity to the Constitution have it backwards. The framers did not design the Equal Protection Clause as a narrow ban on overt bigotry. They designed it as a broad shield against systemic denials of equality. It is Plessy and its progeny that reworked equal protection into a trivial prohibition on obvious class-based laws or provable intentional discrimination, rather than the robust anti-caste principle it was meant to be. Thus, overturning Plessy's lingering approach isn't a liberal judicial revision. It would be a restoration of the amendment's true meaning. If Plessy vs. Ferguson is a ghost, its haunting takes the form of a persistent idea that as long as laws are formally equal or neutral, the Constitution is indifferent to the real-world inequalities they generate. This idea surfaces again and again in modern cases, usually without any mention of Plessy, but unmistakably following its logic. Consider a few examples. Facial neutrality as a safe harbor. Courts often hold that if a law doesn't explicitly classify by race or other protected category, then it is presumptively valid, no matter how egregiously lopsided its impact. This echoes Plessy's comfort with formally symmetric laws. For instance, voter ID laws, criminal sentencing rules, or housing policies that disproportionately disadvantage minorities are routinely upheld unless plaintiffs clear the almost insurmountable hurdle of proving intentional bias by officials. The underlying message is the same: inequality that is achieved subtly or structurally is not by reason of anything in the law, so the disadvantaged group must be choosing to feel injured or simply suffering from societal factors beyond the law's purview. This is Plessy's voice, albeit in a whisper. Disparate impact irrelevant. The Washington vs. Davis line of cases explicitly declares that disparate impact alone is not determinative of an equal protection violation. Almost precisely Plessy's position, except translated to facially neutral policies. Modern courts will often acknowledge stark racial disparities, say in school disciplinary actions or municipal service delivery, and then say, but impact alone does not trigger constitutional scrutiny. That is Plessy's methodology in action. Focus on the form: is the policy race neutral? And bracket out the outcome as legally irrelevant by itself. Structural inequality as non-justiciable. In areas like criminal justice, education, or housing segregation, courts frequently profess that they are not equipped to remedy societal discrimination absent specific intent by a particular law or official. This stance traces back to the sentiment Plessy enshrined that addressing the deeper social meaning or effects of laws is beyond the judicial role, and that requiring commingling of the races or other structural changes is a bridge too far. It's the idea that equal protection does not guarantee any particular outcome, like integrated schools or racially balanced juries, only equal process absent explicit bias. Justice Harlan warned in his Plessy dissent that the court's approach would permit the states to regulate the enjoyment of civil rights solely upon the basis of race behind a facade of equality. Modern doctrine, by focusing narrowly on intent, sometimes permits exactly that, so long as the state is subtle. In all these ways, Plessy's ghost persists. The court may not cite Plessy as authority. Indeed, it is universally vilified. But when the court holds that a law with identical treatment of all races is constitutional, even if it perpetuates racial hierarchy, it is channeling Plessy. When it warns against considering legislative purpose, as Palmer versus Thompson did in 1971, declining to question a city's closure of public pools post-desegregation, or against overemphasizing impact, it is heeding Plessy's lesson to courts: do not look at the outcome, just the surface. We live, in short, under an equal protection jurisprudence that has excised the word deny from the clause in favor of policing invidious motives alone. Why does this historical and doctrinal story matter outside of academic circles? Because it explains a profound disconnect between the promise of equal protection and the reality of constitutional law as many Americans experience it. The 14th Amendment promises equal protection of the laws to all persons. Yet, time and again, people who suffer obvious, measurable inequalities at the hands of facially neutral systems are told that the Constitution cannot help them. Voters in minority neighborhoods wait hours longer to vote than those in white suburbs. But unless they can prove intentional targeting, there's no equal protection violation. Black defendants receive harsher penalties on average than whites for the same crimes. But Plessy says statistical disparities don't count as proof of a constitutional wrong. Qualified minority job applicants are passed over due to criteria that favor majority groups' experiences or resources. But unless someone finds a bigoted email, the courts shrug. This gap between the spirit of equal protection and its narrow judicial enforcement is not a random fluke. It is the direct result of Plessy's methodology surviving in modern dress. The Equal Protection Clause, born as an instrument to dismantle systemic caste, was transformed into a rule addressing only the most blatant individual discrimination. The public may celebrate Brown and think our Constitution unequivocally condemns racial inequality, but the fine print established post-Brown tells a different story. It's a story in which Brown won the battle, but Plessy won the war of how we think about equality under law. Fully overturning Plessy, in method as well as result, would mean returning to a common-sense proposition. If the state in fact denies a group the equal protection of its laws, the Constitution is violated. That does not mean every statistical disparity automatically invalidates a law. Reasonable people can debate standards of proof and the threshold at which disparate impact becomes unconstitutional. But it does mean rejecting the formalistic dogma that only malicious intent matters. It means acknowledging, as the framers did, that laws can oppress by their effects as surely as by their text. It means the law would no longer close its eyes to racial disparities on the pretense that inequality is acceptable if it's not overtly advertised. Such a shift would have practical implications that could improve real lives. Courts could, for example, require governments to justify policies that produce serious racial disparities, putting the onus on the state to show necessity and lack of alternatives. An approach akin to how Title VII handles employment discrimination under disparate impact theory. Legislatures and agencies, knowing this, would have incentive to be proactive about racial equity to withstand judicial scrutiny. Equal protection would become a living guarantee of fairness, not a semantic puzzle. Finally, confronting Plessy's ghost is essential for historical accountability and integrity in the law. We pay ritualistic homage to Brown and the rejection of Plessy's separate but equal lie, yet our jurisprudence quietly maintains Plessy's other lie. That form is more important than substance. It is time to openly renounce that lie. Doing so would not be a partisan or activist move. It would be an act of fidelity to the Constitution's text and the vision of its framers in Reconstruction. It would correct a century-old distortion that has limited the 14th Amendment's scope to the detriment of those it was meant to protect. In conclusion, Plessy versus Ferguson is like the undead. Its body was buried in 1954, but its ghost haunts courts to this day, scaring judges from recognizing real inequalities under the guise of doctrinal formalism. The cleanest and most principled path forward is to drive a stake through its heart, to explicitly restore the Equal Protection Clause to a doctrine about denials of equal protection, not just about forbidden intentions. By fully overturning Plessy and its progeny, we can align our jurisprudence with both the Constitution's text and the moral common sense that all Americans share. That government should not impose or perpetuate caste-like inequalities, even if those inequalities emerge without openly racist laws. The story of equal protection, from the triumph of Strouder and Yick Wo through the betrayal of Plessy and the partial redemption of Brown, is one of an ideal repeatedly deferred. It is time to reclaim the original ideal in full. Only then will the promise of the 14th Amendment, a nation with no caste here, finally be honored as reality, not merely as an aspiration.